So is my mic on? Yes, okay. Thank you, Dean Guzman, Andrew, for those kind words. I'm immensely grateful for the support of the Sachs Institute that the law school is playing. We hope our programs make life better for people who struggle with mental illness and their families and friends, which is to say, most of us. And before starting today, I want to shout out a special thanks to some of our major donors. As Andrew mentioned, the Doris Bree Foundation, the Sidney R. Baer Foundation, and contributions by Rich and Chris Getz. And we're immensely grateful for all of your support in the audience to the extent you can give. I also want to shout out a thanks to Chris Schneiders, the director of the Sachs Institute. He's amazing. I could never get along without him. Raise your hand, Chris. And I also want to thank Gillian Silsby and the media department and the events people, Layla and Marie Cleaves. The school is enormously supportful around these kinds of efforts. So in our symposium today, we want to have a dialogue on civil commitment, on different aspects of commitment, i.e. involuntary care in a psychiatric hospital. We'll speak with a Mental Health Foundation president, a lawyer and law professors, police, judge, emergency room psychiatrist. We will also speak to consumers with mental illness and their experience of involuntary care, as well as the experiences of family members of consumers. And throughout, we will be mindful of the role of capacity and incapacity in this context. We want an open dialogue engaging all these stakeholders on these difficult and important issues. I want to mention, as Andrew alluded to, that I have more than a purely academic interest in this topic. I've been hospitalized here and in England, though it's a long time ago now, thank goodness. The English hospitalizations were voluntary, the American hospitalization was involuntary, and I have my own thoughts and feelings about involuntary care, which I'll talk about as time allows in the program. In a nutshell, I like to say I'm very pro-psychiatry, but very anti-force, though I think other consumers may think otherwise about forced care. Accordingly, I think we should study ways to get people to want treatment so we don't have to use force. So our first panel today is going to be on legal international conversation. And we're honored to have Judith Klein of Open Society, Mental Health Initiative and Open Society Foundations, Montserrat Perena Vicente, a professor of law and senior researcher at King Juan Carlos University, Madrid, Spain, and Candice Player, an associate professor at Northwestern Pritzker School of Law. The international perspective is important, of course, because mental health and involuntary treatment are a global issue, and different countries may have different policies and laws so that we can learn from each other's experiences. So we're not going to have people give sort of speeches. I'm just going to kind of moderate a conversation and see what people have to say. And the first question is, in your bailiwick, international, Spain, America, what is the civil commitment standard?
It's for me. Thank you so much. I'm glad to be here. Thank you, Elyn. Well, in Spain and in all Europe, in some countries of Europe, I will not speak about every country, we have same problems than you here, but we are so different, not only because our law is so different, but because our culture is so different, our resources are so different, so it's not easy to make a comparison between our countries. But in Spain, what we do, how lo que me han preguntado es ¿cuál es la política? Sorry, yes. Um, for civil commitment, we have always the intervention of the court. Our guarantee is that the court must always approve the civil commitment. If there is a situation very urgent, we can put someone at the hospital, but in 24 hours, the court must approve. So for us, it's the best guarantee because the judge the tribunal is the guarantee of liberty and rights of people. It's enough. No, it's not enough. Why? Because sometimes we cannot put the people into the hospital because if they are not consent and there is not one family, one member of his family who consent the intervention, nobody can make the intervention. So sometimes we leave things go far away more than it was good because we cannot make the intervention. So to put the tribunal to guarantee rights sometimes is not good for the health of the person. So we have a system very guaranteed. I don't know, sorry for my English, sometimes like very guaranteed, but sometimes it plays against the health of the person because we have to wait, how to say that, explosion. So we cannot, ¿se me entiende cuando? ¿Sí? So what we must now to do, and we are working on that, is how can we balance between protecting the right of the person, the liberty, his liberty, when he cannot consent medical treatment, and how can we balance this with protect his health? So now we are working to see how can we review our law to make balance better. Because it's not good before this system, we had another one that only psychiatric could decide on a civil commitment. Now it's impossible for us. Only the psychiatric, only the hospital cannot decide. There must be always the tribunal, the court. But we have to balance more because when a person needs a treatment, the court is the guarantee, but he cannot help really the person. So we have to balance it a little more.
Thank you. Judith, what is, your organization is sort of international. And what is there an international standard? What does the CRPD say about civil commitment, Convention for the Rights of Persons with Mental Disabilities?
Yeah, this is on, right? Yeah.
Sorry?
My mic is on.
Yes,
yeah,
it is.
Good. Okay, so yeah, the CRPD is very interesting because 187 countries of the world have signed it. 187 signed it and 177 have ratified it, making it legally binding. In this country, President Obama signed it in 2009, but it hasn't been ratified, and I'm not too confident that the current administration is going to prioritize doing that. So the CRPD is great, but it certainly isn't perfect, and part of the reason is that the international community doesn't have strong mechanisms for enforcing it. In terms of civil commitment, most civil commitment laws do not comply with the CRPD, and that's because most civil commitment laws require a finding of mental disability to involuntarily commit someone or to involuntarily hospitalize and or treat them, and that's usually based on a standard of dangerousness to self or others, and those laws do not use a supported decision-making model. So the CRPD essentially does something radical with all of that because it directs the signatory states to undo starting from the premise of a mental disability. Article 14 is the relevant convention here because it speaks to deprivation of liberty, and it says that the existence of a disability shall in no case be a cause for depriving someone of their liberty. And the CRPD is also interesting in that it doesn't prevent all forms of involuntary commitment. Some people interpret it as saying that it does, but I actually don't agree with that. But what it does is require the removal of mental disability as a criteria.
Interesting.
And that's as a determining factor in the commitment. And I think that is really interesting.
So just to interrupt, you're saying that you can commit someone as dangerous to others who doesn't have a mental illness?
Yeah, well, yeah.
Yeah.
It's really, it kind of, it has to be disability neutral. Because the deprivation of liberty has to apply to people on an equal basis. So it's really regardless of the disability, so that it applies to everyone. Of course, the CRPD doesn't hold the disability as an attribute of the person. It actually thinks of disability as something that is caused by environmental and attitudinal barriers to people, and that if those barriers are removed, then actually, and they can be counteracted, and people can be supported to make their own decisions.
Cool. Candice, so when you think of civil commitment, how would you describe the rights and interests of the patient, doctor, family, and the state that are implicated in the practice of civil commitment, and what would your preferred commitment standard be?
Well, certainly the liberty interests of a person with a mental illness who has been hospitalized are implicated. But in my own research, I've focused on outpatient civil commitment, which is slightly different. It means that there's a court order in place for the person to participate in some kind of mental health treatment outside of a hospital. Usually it's some form of group therapy. It might also be individual therapy, but sometimes people have to allow assertive community treatment teams to come to their homes and do what's called a pill check. And in my research, I haven't had as much access to people who have been under these court orders as I would have liked. But those who I have spoken to have told me that there are also privacy interests that are implicated. It's simply sometimes embarrassing to have your neighbors asking you, who are these people who are coming to your home and what are they doing there on such a regular basis? So it's not just the liberty interests that are implicated, but also the privacy interests. Mm-hmm. What would my preferred approach be? Probably along the lines of the CRPD. I would say that we should not focus on whether a person has a mental illness. My preferred approach would be to ask simply whether the person is competent to make decisions on their own. The Supreme Court has said in a case called Cruzan versus the director of Missouri Health Services that a competent adult has the right to refuse unwanted medical treatment. But that has not been the case with respect to mental illness. We don't have a competence standard with respect to civil commitment. We simply allow a person to be civilly committed if the person is mentally ill and dangerous to themselves or others. But ordinarily, that's not the case. There are many things that my doctor wishes that I would do for myself, but I don't do those things because I am a competent person and I am allowed to make those decisions for myself. But for some reason, we treat mental health differently, and we don't have a competence standard, which is a strange wrinkle in the law.
Yeah, so I get the idea that what we should have is danger to self or others as a result of a mental illness and an inability to advert to the sanctions of the law or something like that, some kind of incapacity component. What would you do with someone who is like completely capable on all standards and tests, but very dangerous to other people?
I think if the person is dangerous to other people, ordinarily the way we deal with dangerousness is through the criminal law. So if a person presents a risk of violence, we don't use civil commitment as a way of restraining that person in advance of the harm that the person might commit, unless the person has a mental illness, which is an oddity. And it seems ordinarily in a liberal society, we ought to rely on the criminal law to address those those harms that a person might commit.
But I guess your position is if someone lacks the capacity to abide by the law or whatever, understand and abide, then it would be okay.
Yes, precisely. But if they do, they ought to have the same rights as the rest of us.
Right, okay, great. So the rates of civil commitment around the world are very varied, and this is old data, but maybe 10 or 15 years ago in England, 3% of the population was involuntary, and that included emergency commitment. And in America at the time, 50% were, and that didn't include it. Are there things you think we can do to kind of reduce our use of civil commitment and get people to want more voluntary care? I wonder how we account for the difference in the countries. Anyone have any thoughts?
Yeah, I mean, speaking of the UK, Elyn, there are these some professors, Smukler, Daw, and Dawson. I don't know if you've read their stuff, but they're proposing something quite interesting because it's a new scheme that they call the fusion law, which is it's really a supported decision-making model, and it's based on the person's impaired decision-making capacity at the time, and this is a key thing. I think it's at the time that they need to make the decision, and it's based on essentially impaired decision-making capability principles, and that's for any person to make a decision about treatment from whatever cause, whether it's schizophrenia or Alzheimer's or whatever it is. And this kind of law requires the person to be as involved as possible in every aspect of the decisions that are being made about their treatment and care. And the person can also have an advocate there. And of course, that doesn't happen everywhere. And I do think that really could go some way toward reducing, the numbers.
Yeah, I'd like to give a shout out to Peter Blank and his group. We're going to be studying supported decision making, where, instead of appointing a guardian, you have the person select supporters to help them make the decision, and it is their decision. And we're going to study kind of downstream effects in terms of satisfaction with the decision-making process and fidelity to the choice made and quality of life generally. So I'm interested in that, and I think that came from the CRPD too.
Yeah.
They talk about supported decision-making. Do we think homeless people with mental illness should be committed as gravely disabled, or do we want to say if they're functioning as well as a non-mentally ill homeless person, that we shouldn't commit them? On the other hand, if they're homeless because of mental illness, we can treat them and get them out of being homeless. What are thoughts that people have about that?
Yes. In Spain, what we try to do, because we have also make desinstitutionalization, but we try not to get out people from hospital to put them in the street or in prison. So we have created a social assistance, a very strong service of social assistance to help people, to help them make decisions and to improve their lives. So for us, it's very important to have a broad point of view, perspective. So it's not only the matter of medical issues, is we have to give people a social network, a family network, but sometimes it's impossible, a work network, so they have, how to say that, they have some people who can help them. So if one person with mental illness has no network, not social network, no, we create for him. We help him to create that. That's so great. Those people near him will help him, support him to or her to make decision. Sometimes it works, sometimes it doesn't work. What happens when someone with mental illness has not network and is in the street? is a homeless. For us, it's something, how to say that, is, in Spain, we cannot support this. It's impossible for us to see that. What we can obligar, ¿cómo se dice? Obligar? Obligate, yes. We can obligate someone homeless to go to some place if he can make decision. No, we cannot. But we try to give him a choice between a lot of things, because someone who is in the street, we have to ask him, you have another choice? You are in the street because you really want and you can make decision? If it's yes, we cannot do anything. But sometimes he's in the street, he's homeless because there's no choice. He cannot choose between some different opportunities. So in those cases, we try to give him some opportunities to help him, to support him, and if then he perhaps can make decision to go to another place. But we can, what we try to do, we can sometimes, some other times we cannot, is to help people, to support people, and even if they have a mental illness, we do the same for everybody. We don't distinguish between people who have mental illness or not. We give them several choices to make decision. If this person, homeless or not homeless, cannot make decision, then we do another things. But on the first moment, we don't make different with those people. Sorry for.
Thank you.
Thank you.
Thank you. What do you think the involvement of family members should be in the context of civil commitment? I mean, I think there's some evidence that if families are involved in someone's care, they have a better outcome, but the person may not want the family in their care, and should we just respect that wish? Especially given that the wish could be based on, knowledge that the person has that the relationship isn't healthy or it's toxic, but it could also be based on not wanting to worry people or being embarrassed. Or what do you think? Do you think we should make an effort to involve family, but that if the patient says no, even if he or she is incompetent, we honor that?
I think so. Yeah, I think exactly that, Elyn. Families can play an incredibly critical role in a positive way, but also not in some cases, as we know. And, and again, it has to be the person who's being subjected to whatever the treatment or the commitment is, who chooses, who their advocate is. And it may well be a family member, but it may well not. And if it's not, if that's a negative situation, then I would say no, they should choose a friend or somebody else,
Yeah.
It makes sense. I understand the impulse, but I think my perennial worry in this conversation is often not just about the liberty interests of people with mental illnesses, but also the equality issue. So why is it that we're treating people with mental illnesses differently? And although I understand the desire to involve families, I wonder, would something like that open us up to an equal protection violation potentially? So. The thought is in the right place, but my inclination, almost like a broken record, is to try to treat people the same, unless we can, is to the extent that we can.
Okay. So in ordinary physical situations, you would not contact the family,
right?
Unless the person said, "I want them to."
Exactly.
Yeah, interesting. Okay. What is your view of outpatient commitment, which is where someone is ordered to be on medication in the community? Do you have thoughts about that? I know you've written a lot, yeah.
I have, and so my thought is there's been a ton of empirical research on outpatient civil commitment. There have been 3 randomized controlled trials, 2 of them in the United States. One found that outpatient civil commitment was not associated with improvements in the outcomes of interest, like reductions in hospitalizations, reductions in the number of hospital days, reductions in arrests, whereas another study did find that there were such improvements associated with a court order to participate in outpatient civil commitment. A more recent 2009 study that was not a randomized controlled trial, but rather a quasi-experimental design in which the researchers matched a control group of patients with who were under a voluntary who were participating in treatment voluntarily, were matched to court-ordered treatment, and that actually found that there were improvements associated with being in under court-ordered treatment. So it seems that, at least in certain jurisdictions like New York, where the program is very well funded and very well organized, it might actually work. But again, there are lots of things that work. But there are limits. I think there are limits to what states should be allowed to do in order to force people to be healthy.
Mm-hmm. Great. Do you have outpatient commitment in Spain?
Yes. For us, Spanish law doesn't allow outpatient commitment. It's not in the law. It's not forbidden, but it's not in the law. So some courts decide that we can do that. Why? Because if a court can order civil commitment, why not something less restrictive? But another courts think that is not possible, so we have a little problem. But now we are in another way. Why? Because we think what is most important is not to obligate one person to go to take medicaments, but to combine her, to speak with her or with him, to take part in the decision of her or his treatment. So it means that we need more resources, because it's not the same to obligate someone to take medicament once a day, once a week, that to take time to speak, to explain, to inform, to say this treatment will produce this effect, this other, this. And so it's more, we need more money. Is that the problem? More resources. But we are in this way. Why? Because there is empirical demonstration that if the person is involved in the decision of his or her own treatment, she will be able to take treatment by him or herself, even if he or she needs some support. But we think we have to work with person and his or her network to involve her in the decision of treatment. When that is not possible, sometimes the court decide, but is most often in the penal cases. In penal cases, the court can decide to substitute one penalty for involuntary treatment out of the hospital.
Thank you. Okay. Why don't we open it up for questions from the audience? We have 10 or 15 minutes. And
we have one microphone here. That's what we want everybody to use for questions. So
Dr. Sachs, thank you so much for...
Where are you?
I'm here.
Okay, thanks.
Thank you so much for putting this together. As a family member in the trenches for 10 years and also in advocacy, I come to these to help understand what I need to do to get my son, who is serious mental illness, better. Yeah. And I want to point out that in many of these discussions, there seems to be an omission of the lack of illness awareness that our family members have. So because the system tries its best, but these are illnesses that are very difficult and complex, and they come and go, our system is a temporary stabilization, discharge, and then they revolve and recycle over and over again, which I think is a terrible waste of money. But what that means is that it falls on the backs of families to be able to find care for them. And often as families, when we hear you experts talk, we sometimes are confused as to, do you really understand mental illness? Do you really know what it's like to live with someone in a crisis? And because the illness comes and goes, it's not possible to do shared decision-making at that time. Now, I want more than anything to know how I can help my son without commitment. And I think everyone who has recovered has gone through involuntary treatment. But I love the Spanish model because I was born in Greece, and there's community there. There are no homeless. There's no poverty, even though this is a country that is not rich. What is lacking is connection, value, meaning. And we don't provide any therapy in some of these IMDs that we have, so that when the person is getting better past crisis, and to stabilize them and have them in a community, the community treatment we have is not really community. It isn't giving them vocational or occupational or all those things. So it's going to be a big jump for us to get there, because we in the United States are very individualistic. But when I hear you talk about the rights of a mentally incapacitated person that I have struggled with and I can't communicate with, it really is kind of frustrating, because we have different perspectives. But, you know, I guess I don't really have a question other than that these comments that we need, and I agree with you that families should not be involved because they're in the line of fire, and often there's one matricide a month. So I'm sorry, that's just comments that I wanted to make, and thank you.
Sure.
Good morning. I thank you for this symposium. Can you hear me?
Yeah, can
So-
you say who you are?
Oh, sorry. My name is Barbara Wilson, and I'm an old social worker, psychiatric social worker.
Okay.
And I've gone, I've been around from the time of Cuckoo's death, where everybody was on involuntary, to where nobody's on involuntary practically. I joke and tell parents that they could get their kid into Harvard quicker than they could get them hospitalized. So, we seem to have gone to one extreme to another extreme. And in America, we have trouble with midpoints. We like extremes. But to the lady in the blue, I don't know your name.
Candice Player.
Candice, you mentioned equality, and I very much love equality under the law. That's one of my favorite boners. And, when we talk about whether or not we would treat people without mental illness in the same way that we treat people with mental illness in a hospital, I'm struck by that comparison, because if I have a person who has a physical illness in a hospital on an inpatient status, I can call patient locator and say, do you have my son? And they'll say, oh, he's in room 222, bed A. That is not the case with people who have psychiatric illness. I searched for my son for 3 years. 3 years. And I didn't know if he was alive or dead. I didn't know if he was in his right mind, if he wasn't. I didn't know if he was even in the state, because he had a yen for travel. Don't know how he got where he got, but he managed. So I'm just saying, I know there is always this tension between individual rights and the right to choose versus society's right to be protected. And if you're committed to seeing people stay alive, as many of us who were culturally involved in some kind of religion, we have this tilt towards we must save people's lives, even if they don't want to be saved, because we feel like if we save them when they come to, they'll be grateful. Sometimes they are, sometimes they're not. But that's our tilt philosophically and I think morally. But when we talk about equality, I don't see where there's any equality with regard to the treatment of people who have serious mental illness and the whole HIPAA thing. I mean, the fact that, you have to keep all this information so top secret implies a level of stigma, even where that might not have been the intent. So I would like to hear your comments about that.
So my thought is simply that we should not be more intrusive on the liberties of people with mental illnesses than we are on the liberty interests or privacy interests of people with general physical illnesses. So to the extent that such a person with a physical illness can have a family member locate that person in the hospital, it would not be, to my mind, it would not be unduly intrusive on the liberty interests of the person with a mental illness to also have that family member be able to locate the person in the hospital, if that makes sense. Yeah.
Then I like that. Yes, thank you.
But beyond that.
Hi, my name is Phyllis, and I want to thank you so much for this day and this time. I came to USC a few years ago as into Rossier School of Education, Marriage and Family Therapy, and graduated in 2016 with every intention of working in this field, doing good. Thrust recently into my son having psychotic features, and we're very new to this. We're about 2 months in. He's already been involuntarily hospitalized. He's been out and non-compliant with his medication. We're trying to keep him from getting hospitalized again. It was not pleasant for anybody. And my question is, excuse me, first of all, Dr. Amador has a book called I'm Not Sick and I Don't Need Help. I think it's an excellent book. And what I would like to find out from the panelists is, in theory, I get the idea of individuals having their own rights, and as they should. In practice, it is extremely difficult if you have somebody who is gravely impaired. It is frightening to look in my son's eyes and see him psychotic. And let me not go there anymore on the tissue. So my question is, when somebody is impaired and then they are stabilized, are there any suggestions as to how to get them to buy in to the fact that they need some assistance and need some help, so that they then can maybe have less poor insight and more awareness of their condition?
It's a really good question. And my understanding is that upward of 50% of people have lack of insight into their illness. I think that's an issue, and I think the reason people have it is because of the, quote, narcissistic injury of being kind of damaged. People don't want to believe that. On the other hand, I don't think we necessarily need to get people to accept they have an illness if it's very painful for them or humiliating. And we can say, look, with the medication, even if you don't have an illness, you've been complaining about sleeplessness and jitteriness, and these pills will help with that. Give it a try. So there are things that you can do short of bringing someone into full insight. And actually, a lot of times when people do get on the medication and stay on it continuously, they come to see that they are ill and need treatment. So I don't know if the panelists have.
Just on insight, I worry a little bit about the use of insight as a criterion that would justify any kind of involuntary civil commitment. Having sat through many a civil commitment hearing in my research, I've seen the way in which that can be used against the person. So the question is often, do you understand that you have an illness? Do you agree with the psychiatrist that you have an illness? That's I think, a dangerous approach. We know that many African American men, for example, are overly diagnosed with schizophrenia. So when the person says, no, I don't believe that I have schizophrenia, are we hearing impaired insight, Or are we hearing an empirical reality that in fact the person has been misdiagnosed? So I just worry a little bit about the potential shift from a competence standard to an impaired insight standard as a justification for any kind of coercive action.
I mean, the person who is going to be most vociferous that they don't have a mental illness is someone who doesn't have a mental illness. So, yeah.
Thank you.
Hi, my name is Libby Hardigan. I work at SHARE, the Self-Help and Recovery Exchange. I have a question for Ms. Perena Vicente, which is, could you speak more about Spain's strategy for community inclusion, which is something that is a strain in our mental health system as well? Could you talk about specifically what can be done to improve community inclusion and develop social networks?
It works? Yes. It's difficult to make a comparison because, like someone else said before, it's so different our country from United States. So in Spain, family network works always. But sometimes when a person has mental illness, important mental illness, family explodes because it's too hard for family. So we have created a network, association network. So we have a lot of association who works for and with people with serious mental illness. This network is composed of two kind of things. Sorry for the. One is private and public foundations. That are foundations who support for people, all kind of support, not only medical or legal support. They are with them every day. So they can take telephone early in the morning to call and to say, hello, today I don't feel good, or today I will need something. So it works very good. But they give also legal support and medical support. And some of them, not all of them, but some of them also provide work network. We have created in Spain what we can call trabajo protegido, ¿cómo diré? Trabajo protegido.
Like a protected work space, like a space where
yes.
people can help.
Protective work. So, because sometimes people with serious mental illness lose his work or cannot find a work. So we have created a protective work, and Spanish law is very implicated in that. Why? Because for those works, we don't pay tax, for example. There are a lot of sorry? Yes, a workshop. So, when we have created all this network for the person is not alone with his illness. And family can help, but it's not the only who that is, because for family sometimes it's too much. They cannot do anything. So, family is near, but not only family, not only the mother or the father or the sister. So they have 3 or 5 persons who are near for everyday's life. What else we have? We have also, I don't know how to say this in English. O sea, lo que quiero decir es que hay asociaciones de familias, family associations.
Yeah, like NAMI or National Alliance for
Yes, family associations who works with people with serious mental illness, and to provide, for example, holidays. Or every weekend they organize tiempo compartido, shared time?
shared time.
share time to go to the mountain or to go to the cinema. Or so we have created a network for people who need and who wants that, because we have also some people who doesn't want this network. So those cases are most difficult, but it's not. Most of the cases are not like this. The network is important.
Because we seem to have a long line here. Okay, sorry.
Of course, thank you. My name is John Halowitz. I am a member of National Shattering the Silence Coalition on the Advocacy Council for Los Angeles County, NAMI. I'm the advocacy chair for NAMI Glendale. More importantly, even though I have a diagnosis, I'm getting over a recent crisis for depression and anxiety, I'm caregiver for 3 people with much more serious mental illness, 2 of whom are practically shut-ins due to their illness. I have one question that is really staying with me, and it's for the professor from Northwestern. You mentioned that when someone is a danger to themselves or others, that we normally deal with that through the justice system, not the mental health system. Well, in our country today, the largest mental health or involuntary commitment of people with mental illness is into our jails and prisons. And as far as equal treatment goes, it's just not there at all. Many of you have probably read Crazy by which talks about a father whose son took a bath in someone's house. And right now, there's a lot of people pushing to get attention on the case in Muskogee, Michigan, of Taylor Daniel West, who is facing up to 20 years in jail for falling asleep in the wrong place. He had a judge in his case early on call him crazy. He has a prosecutor that says he's a menace to society. And they're trying, because he wandered out of his own house and made his way not back to his house, but into the next door neighbor's house and fell asleep on the couch, they're charging him with felony home invasion. He's been in jail for over 16 months, not adequately medicated, but and a psychiatrist has evaluated him as mentally incompetent and told the family, don't tell the court, because going through mental incompetency, at least in the state of Michigan, is much worse than anything else that will happen to him. So they are, at this point, planning at the next hearing to plead him guilty and throw themselves on the mercy of the court and ask for time served. This young man is autistic, mentally ill, and suffers from multiple traumatic brain injuries, 3 of which happened to him in jail when they put him in with violent cellmates who beat him up. And the jail's response was, oh, you were in a fight? For your protection, we'll put you in solitary confinement. To me, this is much worse than getting this young man into the treatment he needed. He was 2 weeks away from a residential placement when they put him in jail. His bail for falling asleep in the wrong place, $200,000. So to me, equality, yeah, it's a great in practice. But if we can do anything to keep Tyler and people like Tyler out of jail in the first place, unfortunately, it's lesser of 2 evils. I believe in persuading people. If you look at assisted Laura's Law in LA County, you have to go through 32 voluntary steps before they'll even take you to a courthouse to go for involuntary. That's the idea. Wherever we fall on the side of voluntary and involuntary, whether it's needed or not, we all want the person to accept treatment. But what do we do about Tyler Daniel West? What do we do about the thousands, tens of thousands, perhaps it's even larger, I don't have the statistics at the top of my head, who are in prison today because of their illness? Thank you.
Judy.
Yeah, I would just make one comment to that, which is that I think, the fundamental problem, not just in the United States, but globally, is that there are just not enough community-based programs that are person-centered community-based programs. Housing programs, for example, are critical, and in many places there just aren't any. So, the prison in this country becomes the default option, which is an absolute nightmare, of course. And employment. Employment is fundamentally important to everyone, including with people who have a diagnosis, and they need to be supported to be employed, because that's a huge part of all of our lives, right? And a very important piece of social inclusion. So I think the lack of good programs that aren't punitive and making people do things and that have too many rules, those are really still missing, and we need to be investing in those.
Hello, my name is Constantine Anthony. I'm with Disability Action of America. My uncle Nick Petrus wrote the Lanterman-Petrus Short Act for California.
Oh my goodness.
And one of his greatest regrets that it was twisted and turned over decades into being the strong arm of the law at certain points. It did good stuff and it did bad things. In January, the Director of Health Services of LA County presented a report to the Board of Supervisors saying, we could help a lot more mentally ill people, a lot of homeless people, if we could just round them up for being on the street, for being mentally incompetent. And Board of Supervisors asked the state to expand greatly disabled to that effect. To their credit, Assembly members Friedman and Santiago are working on Assembly Bill 1971, 1971. They're trying to take into account what Board of Supervisors wanted to do by creating more services for people. My question to you is why is the knee-jerk reaction in this country? I mean, Nick Petrus was Greek, I'm Greek, my whole family's Greek. I love the woman who said earlier, Greece and Spain and a lot of European countries, they start with outreach, they start with community, they start with familial associations. Why is it in this country we start with, well, let's round them up first against their will, and then we'll figure out what to do? How do we change that narrative?
I mean, are you looking at me? That's an incredibly difficult question. I think, part of it is cultural. As someone said before, that we're all very kind of individualistic in the United States. Everybody's kind of for themselves, and with these new generations who are all absorbed in themselves rather than kind of caring about what's going on outside them. I mean, in Europe we do have more of a sense of community in some places. I think that is very strong, and a strong sense of family too. Where families are kind of looking out for each other, and there's a presumption of inclusion, whether or not somebody has a problem, whether it's Alzheimer's or bipolar, whatever it might be. But that's the best answer I have. I hope someone else maybe has some wisdom on that one.
I only want to say in Spain before was not like this, even if we culturally are very different, but it's because people with mental illness and their families demand to the state to do something once and once and once again and once again, that we get a lot of things. But you have to ask for what you want and what you need, even if you are so different from Spanish people. If you don't ask strongly to the state what he must do.
Can I ask what the change happened was in Spain? What happened? Was there a bill? Someone passed something?
Yes, the change was that association of families with persons with mental illness make protests and ask every day. They write on papers, on newspaper every day, 1 year, another year, for what they need. And so we change law.
Okay. Actually,
we have changed a lot of laws to help all of this.
I wish we could take all questions, but it's time to stop this session and maybe people with continuing questions can just come up and talk to us. But we have a 10-minute break. And thank you so much to these panelists. They were really great.